15, our references to Article 29 is only in passing and for purposes of laying basis. That every person, I am paraphrasing, every person has the right to freedom and security of their person, including the respondent. Your Honor, in further laying of the basis, that Article 24 of the Constitution allows for limitation of rights under the Constitution, save for the rights under Article 25 thereof. So that while we acknowledge that the respondent has a right to freedom, right to security of his person, and a right to liberty, all those rights fall outside Article 25 and can be reasonably limited. Where there is justification. And where, Your Honor, it is established that the kind of limitation we are seeking in the nature of detention continuing is the least restrictive measure. So that, Your Honor, once we have established, as we have, that Article 24 permits the limitation of the right to freedom and liberty, then we shall, through my learned senior, take the court through our affidavit to establish the justification. But, Your Honor, Article 49(1)(f)(1) sorry, that is 49(1)(g), Your Honor, I'm sorry. And if you allow me to read, an arrested person has the right at the first court appearance to be charged or, and this is important to us, informed of the reason for the detention continuing or to be released. And so out of the three available options under Article 49(1)(g), we have come to court to seek detention continuing. Your Honor, with that legal basis, allow me to make a reference to the learned Joel Ngugi J, as he then was, in Sudi Oscar Kipchumba.
Can I invite if I get directions? The DPP is making submissions.
Yes.
They waive the right of making submissions after we have made our submissions, so that once they have done this, they will surrender the witness for cross-examination, and they'll have no bite. Procedurally, it is the deponent to be put on the dock, and the deponent is cross-examined. The respondent's lawyers submit, then the state submits. But now it's the reverse, and that's why I'm asking. Is my good JV abdicating the role?
My understanding was that he was just laying a basis so that once the deponent comes to the dock, then they can proceed from there. Yeah. So let JB just finish with your laying your basis. I believe it's more or less like an opening statement.
You have done an opening statement.
Yes. Let him finish.
Then be doing an opening statement.
He did.
To lay the basis.
Yes.
And counter what has been said, because he's doing actually an opening statement. We will also be seeking that we also put an opening statement and before the court.
So please proceed.
Sorry, Your Honor, I do not understand the basis of that argument, because we are arguing our application
yes,
with both facts and the law. So I'm doing the law, then my colleague will do the facts. It's the same thing if we started with the facts.
Indeed.
So I'm almost done with the law. But sometimes he does that to take me off-road, and he knows I never get off-road.
It's his strategy.
Your Honor, I was inviting the court to paragraph 24 of the very erudite decision of learned Justice Joel Ngugi, which sets the test required for the grant of the order of detention continuing, which my other colleagues prefer to call custodial orders. And he says, at paragraph 24, if you permit me to read, so even while accepting that the text of Article 49(1)(f) may, in certain circumstances and contexts, and we submit like this one, comprehend a situation where a person is presented before a court without being formally charged and is thereby informed of the reasons for his continued detention through the state's application, like ours, to have him so held, the state must satisfy a double test. A, first, the state must persuade the court that it is acting in absolute good faith and that the continued detention of the individual without a charge being preferred, whether provisional or otherwise, is inevitable due to existing exceptional circumstances. So that, Your Honor, through the factual matrix, we are going to establish exceptional circumstances. And B, this is the second part of the test. Second, the state must demonstrate that the continued detention of the individual without charge is the least restrictive action it can take in balancing the quadruple interests. You know, this is very interesting. Quadruple interests present in a potential criminal trial. There is a potential criminal trial, and this is the quadruple interest. Number one, the rights of the accused individual, in this case the respondent, who is likely to be charged in a potential criminal trial. Number two, the public interest, order, and security. You know, it is not in doubt that this is one of the great matters of the greatest public interest in the country at the moment. Number three, the needs to preserve the integrity of the administration of justice. We will discuss that in a minute. And finally, and the interests of victims of crime where appropriate. And Your Honor, the court, in cracking its head about it, continues to say, by virtue of Articles 21(1) and 259 of the Constitution, the court must act to aggrandize, not diminish, the personal liberties of arrested individuals in line with the other three interests. But importantly, differently put, the state must demonstrate that there are compelling reasons to deny pre-charge bail while balancing all factors within the complex permutation presented by these quadruple interests, and without reifying or essentializing any. You know, I dare say kizungu kubwa. Having highlighted those two tests, Your Honor, the state is acting in utmost absolute good faith to have presented the respondent within a reasonable time before court. Other than in the police cells, through the affidavit before you, the respondent has been informed, one, of the reason of his arrest, and two, of the reason why the state seeks to continue to detain him. That is a show of utmost good faith. Your Honor, in insurance law, it's called uberimai fidei. That good faith is furthered by the fact, as my learned senior will tell you in the facts, or rather in the affidavit, that there has been some investigations ongoing and that we just need a limited period within which to complete those investigations. And finally, from my part, in compliance with the need provided for under Article 24 of the Constitution, that the limited detention of the respondent is the least restrictive measure we could adopt to protect both the interests of the respondent, the victim's interests, and as equally important, the interests of the public to ensure safety and security. You know, with that legal background, I invite my learned senior, Mr. Jalson Makori, to take you through the factual matrix in the affidavit. I am most obliged unless there's a question from me.
All right, thank you. Thank you, Counsel.
Your Honor Makori.
Yes.
Your Honor, we are referring to the affidavit by one Abdurrahman Jibri. Abdurrahman Jibri, dated the 16th of June 2025. It is an affidavit in support of the notice of motion, dated the 16th of June 2025. Your Honor, I'll only highlight the paragraphs that are in the affidavit. Paragraph 6 sets out the background of the investigation. And these are the preliminary investigations by IPOA, which reveals in paragraph 6A to E, 6A to E, that is on the 4th of June 2025, the DCI received a complaint from the DIG of police, Mr. Eliud Langat, alleging he suffered continued false and malicious publications on an X account, formerly Twitter, with the username Pixel Pioneer, and requested investigations with a view to establish the person and motive behind it. Your Honor, A to E establishes the grounds in which the investigations were mounted. It is at paragraph 6D. On the 7th of June, the DCI team went to Linda Center in Homa Bay County and arrested the deceased at around 2:30 p.m. And they took him to Mawengo Police Station, placed him in custody with the OB number 10/7/7/6, 2025.
Read it again, 10/7/6.
That is 10/7/6, 2025. Then at around 3:54 p.m., the deceased was booked out under OB number 11/7/6, 2025, and escorted to Nairobi, where he was booked at Central Police Station under OB 136/7/6/2025 at 9:32 p.m. Your Honor, we have annexed to paragraph 6E the OB extract, that is AJ1, indicating the time that the deceased was booked at Central Police Station. Paragraph 7, Your Honor, the respondent was arrested. And this is something that would wish the court to take notice. The respondent was arrested on the 13th June 2025 at 18:05 hours, that is 6:05, which was on a Friday. The respondent in paragraph 8 was informed of the reasons of the arrest and for which and the reasons and of the offense that is being investigated. That is under paragraph 8. Your Honor, in paragraph 10, now we are coming to the reasons why we want to continue holding the respondent. The respondent is the custodian of the station records, being an OCS, officer commanding station, and the surveillance system, the CCTV. And this is at the material time under the investigations.
What will be the respondent telling us?
Your Honor,
the information the DPP is giving, it's not them who deponed. It is the one who deponed who should be giving us those paragraphs.
We can talk about it because the
then the
member is here.
DPP can retrace their submissions based on that. Right now, the DPP is turning himself into a witness. And we cannot cross-examine the DPP. It is fair and just. The witness who deponed takes us through his affidavit.
Your Honor, as I said that I'll only highlight a few paragraphs which I wanted the court to take note of.
You know, that's a
Because
it's a dicey situation because
yes,
you're literally taking us through the but I leave because I'm sure you have your own strategy
yes,
on how to prosecute the application.
The
but don't go into details
yes,
of the affidavit. I'm sure the deponent will have a chance.
Yes.
So I'll leave you to proceed, but don't go too much into the details of the deposition. Yeah.
No, Your Honor, I'm only highlighting some paragraphs. I'm not going through the whole affidavit because they have already indicated that they want the deponent on the dock for cross-examination. Yes. Your Honor, what we are... Yes, at the CCTV, yes. We said paragraph 10, yes. The respondent is the custodian of the station records and the surveillance system, that is the CCTV, that is under investigation. Yes, investigations reveal that under paragraph 11, that the respondent, together with others who are not before court, hired a technician to interfere with the CCTV system at the Central Police Station in a bid to tamper and interfere with the subsequent investigations. Your Honor, we are highlighting what so far we have done insofar as investigations are undergoing. So there is still some investigations which we need, and that is the reason why we are asking for continuing detainment of the respondent, because the respondent's mobile phone has been detained. and it is subject to investigations. Your Honor, there are also witnesses who are yet to be investigated and statements taken from them. Also witnesses, police officers who are on duty at Central Police Station on that night. Your Honor, given that the respondent is the OCS, we are saying that there's a likelihood that he may interfere with the investigations. Your Honor, we'll be seeking the 21 days.
I had forgotten to hit on that issue about be allowed warrants to access their phone. You've mentioned it, but please just hit it. In addition to the 21 days, you're also seeking an order to access the phones.
To continue holding the respondent, and in addition to the 21 days, Your Honor, we'll be seeking an order that we access the phones
Number 18. 17 and 18.
of potential witnesses, the police officers who are on duty, and any other person who was at the vicinity at Central Police Station. And this, Your Honor, we are relying upon paragraph 17 and 18, where we have shown in the paragraphs, we have demonstrated that there is already interference, which has already been done. With that, Your Honor, we will be inviting the deponent, the doc, for the cross-examination. Yes. Yes.
Cannot we be seeking that these are turned into an open step to be allowed for 3 minutes open step.
Let it finish.
But
Let it finish. And then
Yes.
Let me see that and not that. Yes, please.
Bismillahirrahmanirrahim. I swear by the name of the Almighty God, the evidence I shall give before this court, touching the matter in question, shall be the truth, the whole truth, and nothing but the truth. So help me God.
You state to the court your full name.
Your Honor, I am Abdurrahman Jibril. Jibril for you, Jibril. I'm a Senior Assistant Director, Investigations with the Independent Police and Oversight Authority.
Yes.
Yes, Your Honor.
Yes, kindly proceed with the affidavit. There will be questions given from the defense.
Thank you, Your Honor. Your Honor, I am one of the investigating officers in the ongoing investigations that IPOA is currently conducting in regards to the brutal murder of Albert Omondi Ojwang. This is pursuant to Section 6, 7, and 25 of the IPOA Act. Your Honor, on 8th day of June 2025, IPOA learned the death of Albert Ojwang while in police custody at Central Police Station within Nairobi County. Your Honor, the authority immediately initiated investigations to unravel the circumstances surrounding the gruesome death of the deceased. Your Honor, so far, our preliminary investigations have revealed that the deceased was arrested following a complaint by the Deputy Inspector General of Police.
Your Honor, all that the witness is saying has been said. You can only adopt the process. Because unless there's any other crucial information.
That's another, Your Honor. That's okay.
Just keep a highlight.
Yes.
Okay.
You okay with whatever you've said so far?
Yes.
And whatever you've averred in the affidavit, yeah? So we can proceed with the cross-examination there?
Yes.
Is that okay? The other team from the state?
That's actually not that.
Okay, okay.
They can proceed to examine on the affidavit.
Thank you. Your Honor, I'll be asking the witness to agree.
So, Mr. Dunstan, maybe just for housekeeping and good order, how many of you will cross-examine him?
3.
3. You, yourself, and who else?
Me, what? Kangai.
So only 3 of you from
Yes,
the battery
we'll
of
cross-examine.
the 3 of
Others will submit.
you. I think that is okay.
Mr. Jibril,
Yes, Your Honor.
can you confirm your position at IPOA over this matter?
You're asking my rank?
Oh, yes. That's a matter.
Your Honor, as indicated, I'm a senior assistant director in investigations.
And confirm that you are an investigator.
Yes, Your Honor.
Are you an investigator in the purpose and the name or position of the National Police Act?
IPOA Act.
Under IPOA Act. And under IPOA Act, is it true that you have still arrested powers?
Yes.
Under which section?
Your Honor, Section 7 of the IPOA Act and Section 7 of the IPOA Regulation Act actually gives me the powers, privileges, and immunities of a police officer.
So Section 7. And which section?
Both Section 7 in the IPOA Act and Section 7 of the IPOA Regulations Act.
Gives you the powers as that of a police officer.
Yes, sir.
And in this matter, you are now actively participating pursuant to those provisions as an investigator.
Yes, Your Honor.
Thank you. Are you well conversant with the law?
Depends on which area you want to ask.
Are you, you know, some of us went to teach, then we became lawyers. Some people are mad about that. Do you have any legal training?
Yes, yes, I do.
Could you refer the court to your legal training?
I'm an advocate of the High Court of Kenya.
Thank you. You are an advocate of the High Court of Kenya. Look at the Criminal Procedure Code, Section 386, as an advocate of the High Court of Kenya. Could you be given it?
Your Honor, we'll have an objection.
Yes.
I've not asked the question.
We can see. Your Honor,
I've not asked a question.
Your Honor, at least should I be allowed to make the objection?
Yes.
Oh,
Let me just object, then you.
no. You wait until I ask. I've just told to look at it. It might be just to admire it. Allow me to ask.
So, Mr.
Your Honor, we'll be requesting the court.
Mr. Danson Omar,
Yes.
let's hear his objection.
That's right.
Yes, kindly.
Your Honor, the witness before the dock
Yes.
has come here on the basis of his affidavit on the factual matters.
Yes.
And that explains why the defense requested that my colleague, my learned senior, does not go into the facts.
Yes.
Section 386 of the Criminal Procedure Code, or whatever provision of the law, is a matter of law.
Indeed.
And Your Honor, the objection again goes into the earlier intended preliminary objection, which we have had sight of, where the argument, in a sense, is that this matter, now we have had a copy, although it's not filed,
Okay.
this matter should have been the subject of an inquest and not a miscellaneous application.
Okay.
So that, because we are alert, the defense should not try through the window to bring in a preliminary objection which they admitted not to have filed.
Okay.
But more importantly, that this is a witness of facts, not a witness of the law. We can deal with the law between the lawyers. Thank you.
Your Honor,
Yes, Mr. Ondati.
is the law a fact? Is he in a court of law? Yes, he is. Is he an advocate? He knows it. What is it that they are appearing and telling us they're coming through the window? If we come through the window, please respond and throw us out of the house.
There is a submission.
You know,
I've not asked any question. I've only told him to look at that section.
but just for guidance, you know, it's a matter of evidence, on the facts. It's an affidavit, for heaven's sake, So let's limit it to the facts of the.
After I've asked the question,
Yes.
then that is when an inference can be done, whether it's a question of law or a question of fact.
All right.
I've not asked what. I've only told him, look at section 380.
Your Honor, just one more thing. The reason we requested the defense at the very onset to inform us of the paragraphs is that the cross-examination is limited to the contents of the affidavit. There is no reference to section 386 in the affidavit. They cannot go to it because it is not a matter of fact. If you pointed to us the paragraph looking at section 386, which we referred to, there will be no objection from our end. But because affidavits are pleadings of fact, we plead with you to reject the invitation of the witness to look at section 386 or any other provision of the law. Thank you.
I think he was referring to section 386.
Yeah, I just only
So
told him to.
let's not convolute it, Let's limit. It's an affidavit.
Purely,
Yeah.
I've not asked any question, Your Honor. If we only had what I've asked you,
Okay.
and I ask a question of law, then the court can stop.
Okay, then proceed and ask.
Let him have that. Let him look at what.
But you know, once you point it to the law, then it means it's,
No.
it's a point of law.
And that exactly is our objection, that we can't refer to the law. Maybe, see, a counsel is not understanding our objection.
Very well.
Maybe counsel, maybe rather than asking him to look at the law, why don't you put the questions to him?
Correct.
Just put the question, rather than us going to the.
Very well. From your affidavit, confirm the place of death of the late.
Central Police Station cells, Your Honor.
Central Police Station cells. From the IPOA Act, provide the mandate for you to investigate somebody dead in a police cell.
Yes, Your Honor.
Read, show the court. Because you have confirmed the scene of death is at the police cell. Which mandate gives you that power?
Still point of
Let him answer.
Your Honor, we are still objecting.
Yes.
Council is still taking the same route.
He came under the Act. You know, section, in this miscellaneous application, paragraph 3, they must have said under which mandate they are coming before this court.
Don't give him answer. Don't give him
And these are witnesses.
These are witnesses now.
He's not an advocate. Let him come in front of you. Let him not be given answers.
No, Your Honor. We plead with our colleagues to just remain respectful. We know that they are very good people. Let us maintain the decorum. What we are asking is, as the court has suggested, put the law to the witness. Don't ask the witness to refer to the law.
Very well.
We do not mind if you read the law to him and ask questions.
Read paragraph 3 of your Act.
Please read for me so that I can answer.
No, you read it. I didn't write it.
Which one?
Paragraph 3.
That investigations by IPOA are pursuant to section 6A, 7.1 and 25.1 of the IPOA Act.
Is that the law?
Yes.
Is that a fact or that is the law?
That is a fact as per this affidavit.
That's what I'm saying.
Yes.
You have quoted the law. True.
Yes.
Therefore, it is not wrong to ask you a question of law because it is you as in your affidavit talked the law. Give me the law that gives you mandate to investigate a person who dies in a police cell. That is simple.
I have indicated the sections 6.1, 7.1, and 25.1.
Just tell the court.
Yeah, Honor, I have indicated section 6A, 7.1 and 25.1 of the IPOA Act.
Could you kindly read to the court those sections that gives you that mandate? The IPOA, just read to the court those sections for the benefit of the whole one. We don't work for IPOA.
Neither do we.
Your Honor, because we did not anticipate
Yes.
that a witness of fact will be made to read the law, we didn't carry a copy of the IPOA Act. If they insist that they want to read it, let them just give us the...
We from selective amnesia when he is cornered. It is there. On any phone. Just read it. Read the section. 6, you read.
Okay. Section 6, Your Honor talks about functions of the authority.
Yes.
Here means IPOA.
Yes.
That the functions of the authority shall be 6A, investigate any complaints related to disciplinary or criminal offenses committed by any member of the service, whether on its own motion or on receipt of a complaint, and make recommendations to the relevant authorities, including recommendations for prosecution, compensation, internal disciplinary action, or any other appropriate relief, and shall make public the response received to these recommendations. Shall I continue?
Yeah, anywhere where the death of a person in police. Specifically, that's all. My question is specific.
Your Honor,
He allowed the witness to read.
This is a question.
Sorry, Your Honor.
Before you even say anything,
Yes.
this is a question that has been put to this witness. It is about what he has said in his affidavit.
Yes.
He's being asked to justify why he is here and what gives him the powers. The state, who has not been asked a question, can now stand and start giving him answers or start supporting him. Let him answer.
Yeah, if Mr. Witty,
Yes.
you have
Yes, Your Honor, I just wanted to indicate.
yes.
Section 6 has been referred to in the affidavit. The witness has been asked to read, he has read the affidavit.
Yes.
The witness is being asked about the law supporting an action which is not in the affidavit. That's where the difference is. The witness is saying that section 6 allows us to do A, B, C. But counsel is asking, does the law allow you to do A, X, which is not in the affidavit? We believe that by him having cited to us the paragraphs he would ask questions on, asking the witness about the law allowing you to investigate deaths in cell, which we have not referred to in the affidavit, is going outside the affidavit.
But
But
I think,
we would be guided.
Mr. Witty, I think it's the bane of contention. So let him answer. If it falls under the ambit of that section 6, let him just say
That's right,
it
that's right,
falls
that's
under
right.
that provision of the law, and let's leave it at that.
That's right.
Yes.
That's right.
And the question we are here about is specific to death inside a police cell. And that is all I'm saying. If he says that section,
Yes.
then the court will go and make a ruling out of it. That's all we're asking. In relation to death in a police cell.
In police custody.
It's not you to set my question. I've asked you my question. You can't set a question and answer yourself.
So, Mr. Jibril,
Yes.
If it's not there,
I
it's
think
not there.
the question is, do you have the powers to investigate?
We have powers to investigate death that occurs under police custody.
And that's good enough.
Yes,
Let's go
and
to the next
custody
one.
includes
The
silence.
court has answered what we have asked.
Yes,
The question has been answered. We'll do submissions on it. That's all.
Yes.
Let's go to paragraph. Paragraph 7. You have paragraph 7?
Yes.
Read to the court what that paragraph says.
Your Honor, the paragraph says that the respondent was arrested on 13th June 2025 by DCI officers and subsequently handed over to IPOA and was later booked at Langata Police Station via OB 50-13-6 at 18:05 hours.
The DCI officers arrested him at what time, according to you?
He said around 3.
You read exactly what you're saying.
I've not indicated the time.
That's what I'm asking.
Yes.
It is not indicated when the DCI officers arrested.
Yes.
Where did they arrest?
At the DCI headquarters.
And the notar Eldoret
No, Your Honor.
found that the accused was not arrested at Eldoret. The respondent.
According to the officers who handed over me to Mr. Taalam, the officers informed me that they arrested him at the DCI headquarters.
Thank you. I'm putting to you that IPOA released false information to the public that he was arrested in Eldoret en route to escape to Uganda.
That is not in my affidavit.
I'm saying what is in social media is that the respondent...
Your Honor, I can only answer what is in on this affidavit.
Sorry, Your Honor.
Let's not digress to those issues of
Yes.
social media.
Let's proceed
Let's-
on the question of arrest. Are you aware the Director of Criminal Investigation, my friend Mr. Mohammed Amin, said the respondent is a person of interest?
That is not in my affidavit.
That's why I said that you're aware. If you're not aware, you're not aware.
Counsel, please ask me what is in this affidavit. I'm not going to, Your Honor, I'm not going to answer anything outside
All
the
right.
affidavit.
I put it to you that based on the DCI mentioning the respondent, on that day at 2 p.m., he presented himself to the DCI headquarters in the presence of his advocate, Juan Keto. Were you aware of that?
If you said so.
Thank you. Putting it to you. And the DCI authorized these officers together with the advocate to present the respondent to IPOA headquarters.
Your Honor, we have said time and again.
I'm
That,
putting it to you.
please,
You don't need to
no,
answer.
no, please answer me ask me what is in my affidavit. Let's stop charges, Counsel.
Counsel, I've only put it to you, I've not asked any question.
Is it in my affidavit?
I'm
The question
putting
I'm
it to
asking to you is it in my affidavit?
For
The answer is
benefit
no.
of the court, I'm putting it to you, then I'll ask you where you are saying you are arrested.
Your Honor, I will decline to answer anything which is not in my
I'm not
affidavit.
asking. I'm not asking.
Then please ask.
I put it to you that the officers handed over the respondent to IPOA in the presence of Mr. Keto. As I put it to you, for the record purposes.
Samson Taalam was brought to IPOA head office by DCI officers.
And he did record a statement at IPOA in the presence of his advocate, Juan Kiprono. Who is it?
Is that in my affidavit?
I'm putting it to you, counsel. You are a counsel. When it's a question, I'll ask you a question. I'm
Please-
only putting to you
please
for
ask me
knowledge
questions.
purposes. So now, if those are the facts, look at the paragraph you said he was arrested. Paragraph 7. Now I'll ask you questions from there. Read.
I have read and read. What is the question, please?
It's a long day.
No, it's a long day, yeah? It's okay. It's okay.
The state is rich, it can bring water.
Yes.
For both of us and council. It's a long day. Can you confirm that paragraph 7 is not true, that he was arrested by the DCI officers?
The respondent was arrested by DCI officers after he presented himself and brought to IPOA.
Do you have any evidence material to that effect? I've given you the scenario the way it was.
The fact that he was brought under the escort of DCI officers means he was arrested and brought to IPOA
The
office.
court has taken that. Let's go further.
Sorry, Your Honor, I think this may be my last objection.
Yes.
We hope that counsel is not proposing to court that he has an alternative set of facts which the court should take note of, because counsel is not a witness. If he wants to give us his alternative facts, we would expect an affidavit so that we also put him on a dock and cross-examine him. Until then, the only factual matters we have is the one given by the witness before.
The only way to prove our falsehoods is by bringing facts that are truthful. The affidavit is full of falsehoods. We are putting exactly the scenario, and your witness has not recounted any.
So, sorry. Your Honor, I am a believer on the law and procedure. What I understand by the law of affidavits is that a person cannot give us factual matters, especially a lawyer or an advocate, from the bar. Right now, we have affidavit evidence given by this officer. We are having an alternative set of facts, which may be true. We have no reason to doubt him. But until we have an affidavit, all that is telling us is, I put it to you. And we hope it does not go to evidence.
No, counsel, just to allay your fears.
Yes.
The evidence that I'm documenting is from him.
That's right. Thank you very much.
Not from Mr. Dunstan.
Thank you.
Because as we put it rightly, he's not giving evidence. If
Correct.
anything, he knows the procedure.
Thank you.
He's a teacher of the law. He knows how
That's
to.
why I told you, Witty now is mature to be a judge of the High Court. Thank you very much. Let's proceed, Your Honor. Paragraph 9.
Yes, Your Honor.
Paragraph 9.
Yes.
You have said what? About the position of the OCS?
That the respondent at the material time of the incident, he was officer commanding Central Police Station, exercising command of the Central Police Station, hence persons of influence, and has capacity to interfere with the ongoing investigations and likely witness.
Do you have any evidence to show that he was in full command at police station?
As an OCS, that is.
I've asked a simple question. It is either you have it or you don't have it. Do you have anything, either duty roster or something showing he was on duty
Your
or
Honor,
in command?
Your Honor, what the advocate is asking is that you are the presiding magistrate here. Do you have the power of this court? I mean, once you are an OCS, you have got the power of another station. Come on, counsel.
We have agreed that you don't have. You are looking for it. Let me put it forward.
And
let me put it to you.
And Your Honor, just to answer also, whatever evidence that I had, I have put as an extra. Anything else which is not here is purposely done to safeguard, first of all, the integrity of the investigations. And they will be provided at the most relevant time. I'm well aware that this will not be the forum where those charges will be preferred. Yes.
So I've asked a simple question.
Yes.
Among the annexures,
there are none.
You produced an annexure showing he was in command of the police station at the time the offense was committed.
I recorded his statement and he confirmed that at the time of the incident, he was the officer commanding station at Central Police Station in the presence of his lawyer. I have not attached in this affidavit.
Simple. The answer is clear. You have
Yes.
not attached. All that's what we were looking
Yes.
for. It's not attached there.
And maybe to answer your question, any other attachment you might ask, it's not there, save for the OB extracts,
Just don't go. And you are a lawyer. When I say I put it to you, don't respond. I've not asked any question.
Then why are you putting in the first place? Why in the first place?
You can put it there. You can put it all over.
Really went to law school, and that is.
Yeah.
I know.
Yes.
See, we have our own legal theory. Allow us to proceed. What is relevant, record. What is not relevant, leave it. I put it to you that the OCS, the police station, and the deputy was in command as an OCS.
That is not in my affidavit.
And I put it to you that the OCS was never near Central Police Station.
That is not in my affidavit.
Thank you. The world has heard it, so to me. Let's go paragraph 15. On the question of him likely to plan. You're there?
Yes.
We have agreed there is no any material.
Yes, nothing
Thank you.
attached to
Let's
this.
proceed.
Okay.
Paragraph 10.
You go back.
Oh, I asked you paragraph
15, yes.
I'm going to paragraph 16, sorry.
Okay.
Still no material attached. It's either very serious material you have kept, no material attached.
Yes, Your Honor.
Thank you. Paragraph 17 about the CCTV.
No material attached, Your Honor.
Thank you very much. Paragraph 18.
No material attached.
No material attached. Paragraph 17.
Come on.
I've gone back because there's a question I want to ask.
Yeah, please ask.
You have said about the CCTV cameras. Do you have possession of the scene of crime as of now?
No.
Who is in possession of the scene of crime?
The scene of crime was processed and released. Remember, that's a police station. You cannot hold a station as a crime scene for a very long time. So we have released to the relevant authorities.
Is that on off? Because I was there yesterday. It's not true that the scene of crime has been released to the police.
Then
Is it still a scene of crime, or it is non-operational police station?
that question is not. It's not in my affidavit.
You've run very fast. Do not lie that is. So you cannot. There's no material to show that.
Nothing attached, Your Honor.
Paragraph 19. You've read it?
Yes, Your Honor.
And 21, they are the same?
What's the question? No material attached.
There is no material attached.
Yes.
That is very, very critical to us. Paragraph 22. I still ask you this question about the blue code of silence.
I will refer you to the High Court decision.
Tell the court. This is a lawyer. He knows High Court decision.
Court of Appeal decision.
Give the court that decision.
In the Titus Ngamau case, 2020. It was a phrase coined by the judge who was dealing with that matter.
And I remind you, Cliff is the one who argued that matter.
Yes.
He's here. He'll face you over that matter.
It's okay. It's
The
okay.
one who argued that matter. Cliff will deal with the blue collar. Paragraph 23. You are now providing reasons as to why you want him to be detained for 21 days. True? From paragraph 23.
Yes, Your Honor.
What is the reason you want to detain him? In paragraph 23.
That we are yet to record critical witness statements.
Very well. Is his presence required physically when you are recording statements from other people?
His detention is required so he doesn't interfere with the witnesses.
About recording statement and interference are two things. Wakili,
I have responded to your question. The reason as to why I'm seeking that prayer is to have him detained so that he doesn't interfere with the witnesses.
Very well. Does he know the witnesses?
Them being police officers? The answer is yes.
Is there anything you have shown of any attempt to interfere with witnesses? Because, Counsel, you know very well the authorities, the Sagari, Duat Sagari, Cliff will ask you. The questions I'm asking is to prove, have you demonstrated by material your varmint?
Nothing attached.
Thank you. Important answer. Paragraph 24. What are you addressing?
That we are saying if released, his security is not guaranteed due to the public anger demonstrated by the case. I've just read what is in the affidavit.
Yes.
I'm saying that the gruesome murder of the deceased has elicited widespread public anger. And therefore, if released at this point, the respondent's security cannot be guaranteed.
Mr. Witty took us a lot about the case of Oscar Sudi. Heavily. Have you ever had a chance to read paragraph 32 of that decision of Professor Justice Joel Ngugi?
Not in my affidavit.
It's not in your affidavit.
Yes.
For the benefit of doubt, you are saying you want to detain him on two limbs. One, for the safety of his life. True?
Yes.
Do you have anything to show that his life is in danger?
Nothing attached.
Do you have anything to show that he is a danger to anybody of the public?
Nothing attached.
So it is an apprehension.
Yes, Your Honor.
Thank you. It is an apprehension. Lawyers swear to be court officers. It is an apprehension. And you are very aware that the National Police Service is the one mandated to provide security for everybody in this country, including the already convicted murderers. You are aware of that?
Not in my affidavit.
No. You will feign to be not understanding what I'm asking. I'm asking you this question. The duty to protect life and property falls under the police.
If you say so.
And this country is not a banana country where the rule of law has broken. So it is not right to say you are preserving his life in cell. And he pays taxes. Everybody pays taxes to be protected. And that it will be dealt with in the cases that I've talked about. Now, what other reason do you need him in cell to detain him for 21 days?
All I stated
what
in my
do
affidavit.
you specifically want him to do?
All I have stated in my affidavit.
Is there any other reason we have not dealt with?
Everything I require, I have indicated in my affidavit.
Confirm you have his phones.
His phone.
His phone, you have it.
Yes.
And you are seeking this court. Did you have the court order to possess that phone?
I don't need a court order to possess a phone.
Do you need a court order to get access to the phone?
Yes, I do.
Where is the provision that does not allow you to have authority to possess?
It's a seizure.
Oh, wait,
Sorry, no. Yona, where is the provision that does not allow you? Surely.
Where is
You
the
are asking
provision?
for a provision which does not allow you. This is a negative provision, does not exist in our law. He should tell us the positive provision, and council can put it. He can continue putting it to him that this provision does not allow you, not the negative provision.
Maybe refresh your question.
I'm rephrasing. You know, which has a problem is preparing for the judgment. It's not akin to this matter. You need him 21 days for the sole purpose of granting access. Is it him who grants access or the court?
No, Your Honor.
Who grants?
I need the 21 days to complete my investigations.
I've asked a question specific. Do you need my client in cells for the purpose of analyzing the phone?
I need your client in custody for 21 days to complete my investigations.
I've asked a simple question. Is there any role he's required to do in forensic analysis of our phone?
I'm not an expert in forensic analysis, so I cannot say.
So, your arguments are not based on any scientific, because you never consulted a forensic expert? It is you swearing 21 days.
Yes.
And I've asked you, should the court, why 21 days? Why do you need him specifically?
Your Honor, the issue is not about only phone extraction. It's not only about phone analysis.
What else?
I have said to complete my entire investigations that entail so many things. Among them, what you have stated.
And lastly, you have already attached the order in your application. Look at it. We have an order. True. Makori, this is a competent advocate and witness. Let him answer.
No,
I have seen an annexure here.
Can I check yours?
I've seen an annexure there. We were given an annexure that has. Is it yours?
Yes.
Or it is on it?
No, it's ours.
Very well. Let me ask you the question. You are certain you are getting
It's a draft.
these orders?
Council, this
No,
is a
no,
draft.
no.
It's a draft.
Which is saying, is the office of the DPP or IPOA that gives the orders, or is the landed court? What is the import of you drafting an order? Is it a formality that in this court already you have decided, not the court to decide? Who decides? I hope it ceases from being
I hope
the norm.
we can save time by admitting that the application was drawn by the office of the DPP. What we have annexed as an order is a draft order. It is not the first time today, is it 18? It has been done since I was a law student at the University of Nairobi, where we do draft orders. The court can reject it, it's not binding on the court. So that we save time for counsel and his client. We
Which have only for good practice.
We admit.
Avoid doing the judicial work. Leave the courts to do their works.
Let's not delve so much on that. Yeah? Yes. I think what Mr. Wick is saying is just practice that they have adopted from the DPP's end, which is not a good practice.
It is not good practice.
So let's leave it at that.
If I sat in that office, I wouldn't allow that. But I was chased. Thank you very much. Let me allow Mr. Kangai to proceed. Oh, sorry, Your Honor, I said if an advocate is not allowed to talk, I will be stoned out. Put Mr. Shadrach on board. He has just left class to come out. He was teaching till he's late on the forum.
Your Honor, sorry, it's after.
No, this is affidavit. So what is the problem?
They will Shadrach, they will just try to put you in order. It should be a difficult one. After Mr. Shadrach, Mr. Keto will lay his legal basis. Then I'll wrap with the application. I think with Umbeta and Unju will be making after admission on that.
Your Honor, with your permission, I will ask very few questions to my colleague, Mr. Jibril. Unlike my seniors, I am the soft one.
And I hope you are around so that you don't ask again the same questions which I have already answered.
I teach law, just relax.
I think Mr. Jibri's sentiment is valid.
Yes.
I was about also to make the same commentary.
The problem is his body.
Yeah.
Cliff, make sure he eats what.
Yeah, so that we avoid repetition.
Mr. Jibril, I want you to confirm to the Honorable Court that indeed one person of interest in the matter surrounding the death of the late Albert Ojwang is the Deputy DIG Edward Lagat.
Please repeat your question.
I want you to confirm to the Honorable Court that the late Albert Ojwang was arrested pursuant to a complaint made by the DIG, Mr. Eliud Lagat.
Yes, Your Honor.
Thank you. You also want to confirm to the court that from your preliminary investigations, the late Albert Ojwang was arrested and put in police cell, largely due to the complaint that was made by Mr. Eliud Lagat. Is that correct?
Yes, Your Honor.
Thank you. You confirm to the court that the investigations you seek time to continue with are investigations meant to assist you to unravel the persons who should be held culpable for the death of Albert Ojwang. Is that correct?
Yes, Your Honor.
Thank you. Please inform Your Honor the name of the chairperson of the body where you are coming from.
Your Honor, I think we've agreed that what I'm going to answer is what is in my avowment.
Please, just listen.
No.
This is cross-examination.
I decline to answer that question, Your Honor. It is in public domain who is the head of IPOA.
Just respond. That is your work here.
I'm responding.
Please respond. Who is the chairperson of IPOA? That is your work.
My response is it is not in my affidavit.
Yes, yes. JV, just inform me.
No.
I mean,
Your Honor, we have agreed that I will be cross-examined on what is in this avowment. The chairman of Independent Policing Oversight Authority's name or his position is not in my affidavit.
But you know you come from that
Yes.
background of
Yes.
IPOA, so it's...
And the council knows who is the chair of the IPOA.
please answer the question. Who is the head of the body where you hail from?
We don't have a head. IPOA does not have a
So
head.
who is the chair of the IPOA?
Yes, that should be a right question. The chair of IPOA
Answer, yes.
is one Ahmed Hassan Isaac.
Thank you. Thank you. Now, you confirm to Your Honor that there was a joint press conference on the 9th day of June 2025. Is that correct?
Your Honor,
No,
I'm not going to answer anything outside my affidavit.
Your Honor, if you permit me, just to also give context why I am asking this question. Your Honor, my learned senior and friend, Mr. J.V. Owiti, went to a very large extent in explaining the authority that was made by my Lord Professor Joel Ngugi in the Oscar Sudi case. Some of the parameters that were set by the Honorable Court were two. I think that is paragraph 24 of that authority. On the question about bad faith
the question about exceptional circumstances, and lastly, the balance of the quadruple rights that the court should look at. One of the items that we have a duty and responsibility to prove to you is to demonstrate to you that indeed there is an element of bad faith in the application that has been made before you. And that is why my questions are aimed at eliciting some of these facts based on the evidence that is going to present before you. So, Your Honor, I plead with humility that counsel, my colleague, I even suppose he's my senior. My senior should just
I'm not
be
your senior.
kind enough to
I'm not your
respond.
senior.
So
Yes,
Mr.
it looks
Jibril,
like deceitful, but
what you can answer, just answer.
Yes.
If you can't answer, you don't have to answer. Yeah. What you can answer, what
Yes.
is in your information, whatever you have in your knowledge, just answer. If you don't have,
Your Honor.
You cannot argue with the court.
No. Order. Chair. Let me say this. Let me say this for the record. No, let me say it for the record. And Your Honor, protect me.
yes.
The counsel who is on the floor asking questions should only answer.
Okay.
Learned senior should stop pointing at me.
Who is this?
You will have your time to ask me questions if you require. The second, Your Honor, the second point I'm making here is that anything outside this affidavit, whether our chair...
It's not within your knowledge.
It's not within my knowledge. And please stop asking me. Anything outside this, I'm not ready to answer. It's not within my knowledge. And believe.
What is the basis of what happens to your ruling?
And after all, Your Honor, the application we are making is about an extension of continued detention of the suspect. It's not about what happened on the backyard.
And you know,
What
that's
you're
why,
pointing is bad faith.
Mr. Jibril, that's why he was trying to lay a basis, Mr. Shadrach Wamboi.
We have gone for 2 minutes. Get advice by Wamboi and others.
You just give us a minute.
So we take a break.
Yeah, we'll take a break.
We don't need a break.
No, we don't need a break. We don't need a break.
Okay, it's okay. So the court is still in session. Kindly, the court is still in session. If you have to converse, just do so quietly.
So don't take us. Yes, that's what they're saying. So calm down. Just answer. Yeah, thank you.
Oh, we are now okay. So let's just have civility and decorum.
Yes.
Yeah, we're not fighting. Yeah, we want to know the truth and to assist, also for both parties to assist the court. Indeed. So I'll allow Mr. Shadrach Wamboi to proceed. Yes.
Mr. Jibril,
Yes.
counsel, please confirm to Your Honor that there was a joint press conference on the 9th day of June 2025 where the chairperson of IPOA was in the company of Mr. DIG Eliud Lagat and the Inspector General of Police and others.
I'm not aware.
You are not aware. Thank you. So you have not, Your Honor, you have no information that indeed your chairperson held a joint press conference with one of the persons who's been constantly mentioned in the death of the late Albert Ojwang. You have no information, isn't it?
Your Honor, the chair attends several press conferences.
Leave those several.
So I don't follow the chair.
Thank you.
I don't follow the chair for his press conferences.
Thank you. Now, Your Honor, that is very important. You have been very honest with the court. Now, I want to return to paragraph 27 of your affidavit. Yes, paragraph 27. You have made mention that the reason why you are inviting the court to order the pre-charge detention of the suspect before court is because you have fear that he might run away from the jurisdiction of this court, isn't it?
Yes.
have you, in your well-elaborate affidavit, demonstrated an instance where probably he was invited, he never turned up, or you have proof that he has already booked a ticket to a certain foreign land that he presented before court?
That is not in my affidavit.
No, you have in your affidavit.
No, I'm saying
yes, yes.
The answers that you're looking for is not in my affidavit.
No, I am asking a very straightforward question,
Yes.
likely to attract a yes or no.
Yes.
I am asking you again. In lieu of your paragraph 27, on the question about the temptation by the suspect to run away from the jurisdiction of this court, if allowed his liberty, have you provided before this court
No.
any material?
No.
You don't have any material?
No.
Thank you. Your Honor, that should be all from me. Thank you.
I believe we have exhausted the cross-examination. Oh, there are three.
Yes, the two. And I'm actually going to take very limited time in the form of 2 minutes. 2 minutes.
I'll leave it to three. So we can do something.
Then I can do 125 minutes, depending on how it's
Okay, then. So you'll go first or she'll go first?
Now, Mr. Jibril, I want you to remember the testimony that you've given us just a few minutes ago, where you told us that the scene of crime was processed and released to the relevant authorities. Is that still your stand?
No, it's not in my affidavit. That's my answer.
Yes. You made a representation to this court and told us that the scene of crime was processed and released to the relevant authorities. Is that correct or not correct?
Now, Your Honor, the scene of crime here I'm talking about.
Is it correct or not correct?
The cells where the deceased died has been processed and released to the relevant authorities.
Okay. Thank you. Now, can you tell us the investigative steps that you have used to preserve the CCTV and the occurrence book?
The occurrence book is a digital. It's not.
It's a digital.
It's a digital. Yeah.
Is it with your possession right now?
No, it cannot be.
It cannot be.
It cannot be in my possession.
Have you extracted the relevant entries on that particular day?
Yes, and attached to the affidavit.
Thank you. Now, number two, about the CCTV, can you tell us the preservation measures that you've taken to preserve the sanctity of that CCTV footage?
Your Honor, we are a team of investigators. That aspect is being done by the forensic team.
So you can also confirm that the CCTV in itself is not with the police station. It is with the forensic team.
No, what was extracted is the only DVR. But the entire, you can't carry a whole screen.
It's okay. That's what I want you to tell me.
Yes. What was extracted is only the DVR.
Yes.
Yes.
So the DVR that records the events of that fateful day is the forensics team.
Yes.
Thank you. That's all you want.
Yes, Sophie.
Good morning. Good afternoon.
Good afternoon. I kindly allow me to ask you just 3 questions. I want to take you from paragraph 6A. We are where you say the PCI received a complaint from the Deputy Inspector General of Police. Confirm?
Yes, Your Honor.
Was it an oral complaint or a written complaint?
It was a letter, a formal,
letter.
yes, a letter to the
Have you
DC.
provided that letter to this court?
No, it's not attached here.
It's not attached here?
Yes.
Thank you. Kindly go back again to paragraph 7, where you say the respondent was arrested and under the Langata police station OB number 50.
Yes, yes, Your Honor.
Who booked the respondent at Langata police station?
The booking was done by myself.
It was done by yourself?
Yes.
Thank you. Are you aware of the law governing the booking of a person at the police station?
As per the IPOA Act, yes.
As per the IPOA Act?
Yes. And the regulations.
Are you a police officer or a former police officer?
I'm not a police officer. I'm an
Have
employee.
you ever been a police officer?
Yes, I've been a police officer.
You have been a police officer?
Yes, Your Honor.
Thank you so much. Paragraph 51. Now, paragraph 51, you are saying there are co-conspirators. Confirm?
21, yes.
Do you know the co-conspirators by name?
That is part of investigations. I cannot reveal it.
No, I'm just saying, do you know by name, not their names. Do you know them by name? Because you have said there are co-conspirators. Do you know them? Not by name.
Okay, she's not asking you to name them.
Council, it's what I've been saying. Let me answer. The thing is,
But let me help you to do that.
Yes.
Just say yes or no. Do you know the co-conspirators?
The matter is under investigations.
Yes or no?
As of now, no.
You don't know them. Thank you so much. Number 2. You have said that there was the murder of the deceased was planned, executed, and that their attempts to cover up. Do you know the people who are trying to cover up the death of the deceased?
One of them is your client.
Do you know that it's certainty?
Yes.
Have you provided evidence to that effect? Or
No.
the attempt to cover up?
It's an investigation, but not attached to this evidence.
You have said that, yes, you know the client is one of the people trying to cover up. My question is, have you provided evidence that he is one of the people who is trying to cover up?
As of now, no.
No.
Yes.
Thank you. Thank you so much. Thank you, Ronald. That is the
I think, Your Honor, that will be the end of cross-examination of the witness. We will lay now, once he is discharged,
Yes.
Piton will lay the basis for our next line of approach.
Mr. Whitty, anything?
Even we would learn a few minutes of re-exam.
Okay.
That follows cross-examination.
I think that is all.
Mr. Jibu,
Yes, Your Honor.
my work is to calm you down completely and make you smile.
Actually, I'm calm and composed.
I'm glad. Thank you. Now, I will limit my questions back to the contents of your affidavit, many times by paraphrasing. What is the basis of your request for detention continuing in one line?
To complete my investigations.
On a scale of 0 to 100%, how much could you, by approximation, attach to your investigations up to now, on a scale of 0 to 100%? Doesn't have to be accurate, approximation.
49%.
49%. So I can mathematically say this as direct evidence that you're saying there is 51% of investigations to be done.
Yes, Your Honor.
So that there are questions about who is in charge of the cells, who is in command of the station. Do those questions relate to the remainder of your investigations?
Yes, they do.
Now, to ask another direct question, are the questions from the defense some of the things you need to investigate to complete your investigations?
Yes, Your Honor.
Thank you very much, Your Honor. I'll hand over to Mr. Johnson.
It's just one question in the examination. You have been asked whether you have attached any document relating to, I think it was paragraph 6A, some paragraphs in your affidavit, whether you have attached anything to show that even the respondent is a flight risk. Why do you need the respondent in custody? Is there any reason why you have not attached?
Yes, Your Honor. The reason I have not attached what I've collected so far, the 49% I'm talking about, is that it will jeopardize the investigations. And this is actually to protect the integrity of the investigations. That's why we cannot divulge much.
Thank you very much. believe that is all from my end.
Thank you, Your Honor.
I'm glad that you confirmed that you account.
Yes.
Thank you.
Then allow the next phase of our team, led by Ketu. Now we proceed to take out family.
We can proceed, yeah? It depends how you tell
As we are ready, sure, all the asking for the benefit of.
How many would be submitting?
4.
Starting with it. Let's
There's
just proceed.
Kiton, there's Langat, there's the QC.
You okay with that? Or you need some break?
We are fine. We are fine.
We proceed, yeah?
The only thing that we'll be asking is there something that has been filed so that it can be served, or it's an oral.
Let's see what they will argue.
Yes.
If there's anything, then you can
We'll
raise
serve
them.
you with authorities. Simply.
All right, then.
Our team serve the state of the whole.
So we can. So I'll just urge brevity, you know, because these issues we've argued it severally. So just brevity and just direct to the point, yeah, in submissions, yeah.
Your Honor,
Thank
for the
you.
record,
Yes.
I remain Felix Keaton.
Keaton, yes.
And also, there's also another additional attorney at law, Vincent Yegon, also is part of the defense team.
Present, Your Honor.
Okay.
Your Honor, we reiterate that we vehemently oppose the motion application dated the 16th of June 2025. And from this motion, Your Honor, there is only one salient issue for determination. That is whether there are compelling reasons for continued detention of the respondent. Your Honor, permit me latitude to lay the legal basis. It is our humble submission, Your Honor, that the issue or the question of pre-plea, pre-trial, or pre-charge detention has been settled in law, is well settled in law. And as such, Your Honor, Article 49(1)H and 49(1)G of the Constitution is very clear that an arrested person has a right to be released on bond or bail unless there are compelling reasons. Your Honor, in order to conceptualize and also problematize the issue, Your Honor, permit me to refer you to the statute, which is section 36A of the CPC, of the Criminal Procedure Code. And in order also to contextualize the issue, Your Honor, is that this section 36A was an amendment following the locus classicus in Michael Rotich, that is in Michael Rotich versus the Republic, the 2016 decision, whereby, Your Honor, in this section, it lays the two-tier threshold for such an application to succeed. The first burden, Your Honor, is on the investigation, that is the IPOA. And the other also burden also, Your Honor, rests with the Honorable Court. And as such, Your Honor, under section 36A, it is very clear that pursuant to Article 49(1)F and G of the Constitution, a police officer shall present a person who has been arrested in court within 24 hours after being arrested. And now it lays now what they done, which we admit that. Then the second thing, Your Honor, is that they must apply in writing. And they have done that through this motion application. But now, Your Honor, the greatest issue that they must also do, Your Honor, is that under section 36A, clause clause 3D, it states that the investigation must also adduce the reasons necessitating the continued holding of the suspect in custody. So the question that begs our attention at this juncture, Your Honor, is whether there are reasons necessitating the continued detention of the respondent. And we submit, Your Honor, in negative, that the investigations have not adduced any cogent reasons necessitating continued detention of the respondent. And Your Honor, my learned friend, they have already gone through the cross-examination limb by limb in the entire affidavit. But if you may permit me only to refer you to 2 or 3 salient issues, Your Honor, in order to illuminate why this motion application is bereft of meat and substance to stand on. First, Your Honor, I will refer you, Your Honor, to look at paragraphs 9, 10, 11, and 20 of the affidavit. They are building a case that you should continue detaining the respondent because he's likely to interfere with the investigation. We submit, Your Honor, that that is not a cogent reason. And we'll invite you, Your Honor, to consider the authority which we are provided, that is Republic versus Mercy Chebet. It is a 2022 decision whereby Justice Gigonyo has indicated succinctly, and I'll humbly refer you, Your Honor, to paragraphs 17, 18, and 19 of that decision, whereby the High Court has settled the law that for such a threshold to succeed, the investigations must tender material information to the Honorable Court to demonstrate the nexus link that is between the respondent and the likelihood of interference. And I will also refer you, Your Honor, to also adopt the reasoning of Justice Mutuku in Republic versus William Chirchiri and Godfrey Kirui, whereby the same threshold.
Your Honor, this is not an objection. It's an humble plea that counsel shares the decision with us, and that it is generous enough that he also points out the paragraph that is paraphrasing, so that we are able to respond to them.
Your Honor, we have already filed our list and digest of authorities, dated in 16th of June 2025, and you can confirm, Your Honor, that they are there. The decisions and everything, we have already finished. It's the last decision.
The last one.
Counsel, the one which is on the is the one.
Sorry. I am looking at your document, sir. I am alert.
Thank you.
The document written respondents list and digest of authorities.
Yes, Your Honor.
I am looking for Mercy Chebet. Do you have it in the list?
There is another one which is look.
So it's not in the list.
No, it is in the. Is the one you are holding.
Thank you.
So
This is the list. It does not have Mercy Chebet. Does it have it?
You already have an authority, the one next to your phone.
You know what we are informing the court is that we didn't have it in the list. So if he has added it, that's okay. That's
Yes.
what we're asking.
They
So we can have
the
the
authority, Your Honor. We have already finished. Yes.
And I think I'm comfortable. I have the Mercy Chebet.
Yes.
But I don't have the William one. William Chirchiri.
Yes.
It's also part of.
Yes. So Your Honor, if I may.
Did you file for the William? William.
It appears there was an oversight, Your Honor, but I know the court takes judicial notice of all the citation or all the authorities.
Yes, I
You
think.
have already provided the citation, Your Honor.
So we can proceed, counsel.
Sorry, Your Honor, he has interfered with the flow of my
It's
thoughts.
okay, we'll give you time.
My apologies. My apologies. I am not in that business like my colleagues. The two that must
So what you are saying, Your Honor, at paragraph 17, Justice Gigonyo has laid the threshold and also illuminated that interference with witness undermines the criminal justice system and dents the integrity of the criminal process. And he goes on and also says that for such a ground to succeed, the prosecution must tender or must present material information to the Honorable Court. And the earlier decision which we have also cited, Your Honor, the William Chirchir case, whereby Justice also Mutuku has said that there should be a nexus between the respondent and also the stated interference, Your Honor. So that was the main ground, Your Honor, that has been advanced at paragraphs 9, 10, 11, and 20 of the affidavit. Another link, Your Honor, of the affidavit is that, Your Honor, I will humbly beg to refer you to paragraph 24 of the affidavit, whereby you have been told, Your Honor, that the gruesome murder of the deceased has elicited widespread public anger and outrage leading to demonstrations, which at times have been destructive. Hence, the safety and security of the respondent cannot be at this point be guaranteed if released on bail. So in order, Your Honor, to demonstrate that such a reason, Your Honor, should not hold waters is that we will humbly beg to refer you to the same decision of Justice Gigonyo, that is Republic versus Mercy Chebet, whereby at paragraph 20, which is also titled Safety and Security of the Accused Person, the judge lamented, Your Honor, at paragraph 21, that I have lamented time without number, and again slide into grief. How and why in this age and time should people take the law into their hands to harm the accused? The community herein is within the territorial jurisdiction of the Republic of Kenya, a nation governed by law and order. And under the Constitution of Kenya 2010, I wonder whether the said community will derive the authority to harm or kill a suspect under trial. No one is above the law or should take the law in their hands. All are bound by the Constitution which reigns. And the community in question should let the law punish the accused. This should stop, and my view is that ground that the security of the accused is threatened by the members of the public or victim family should never, and mark my words, Your Honor, should never be encouraged to be a ground for denial of bail. Otherwise, the courts will inadvertently promote or condone violence, disorder, and usurping of law by individuals or group of people. We say no more, Your Honor. Such ground should fail in limine. The court, the High Court, has settled the law on that. On the other hand, it is even the duty of the police to also guarantee the safety of the respondent. And you have also been told other issues, Your Honor, that they need time to do forensic, to subject the gadgets to forensic, etc., etc., etc. We submit, Your Honor, that all those reasons that have been given, it can be done without the need for any custodial order. So we submit, Your Honor, that from all the reasons that have been adduced, none is cogent and none should pass the master of the law, because they have already done what they ought to have done, and any proposed investigations can be done without the need of subjecting the respondent to custody, Your Honor. Having submitted the limb, Your Honor, that they have failed to demonstrate the reasons necessitating further or continued detention of the respondent, Your Honor, we submit on the second limb, whereby their statute also, Your Honor, has also given the court the latitude or guidance on what should do. And we shall invite you, Your Honor, to consider Section 36, Clause 5 of the Criminal Procedure Code, whereby it is stated that a court shall not make an order for the remand in custody of a suspect under subsection 5 unless there are compelling reasons for believing that the suspect shall not appear for trial may interfere with witnesses or the conduct of investigations or commit an offense while on release. So, Your Honor, even if it's submitted that they have not adduced that reason, that is a duty that the court also must also satisfy itself before granting any custodial order, that there are compelling reasons that the suspect will not appear during the trial. And there is no such reason that has been advanced by the state, Your Honor. And the other aspect of interference, Your Honor, we have already submitted that there are no material information to persuade you that there is a need to further detain the respondent, Your Honor. And in doing so, Your Honor, on the duty imposed on the court in the two-tier threshold, that is the threshold in the second tier threshold, which is the duty of the court, will invite you, Your Honor, to adopt the reasoning of Justice B.J. Otieno. That is a High Court decision in Ramadan M. Hassan versus DPP. It's a 2017 decision, whereby at paragraph 15 of that decision, Your Honor, it is at pages, we are finding that authority. It's at pages 43 to 46 of our bundle, whereby the judge reasons this way, Your Honor, that I must add that a judicial officer before whom an application is presented seeking to limit the enjoyment of a suspect's fundamental freedom akin to the right to liberty is duty-bound and enjoined by law and the Constitution to be extra vigilant and not to interrogate whether the facts presented to it meld the dictates and spirit of the law invoked before it and are in consonance with the attributes and general philosophy of the Constitution, which guards against arbitrary and unjustifiable limitation or enjoyment of rights and fundamental freedoms.
Those are live images coming to you live from Milimani Law Courts, where there is cross-examination that took earlier. That is Rahman Jibril, Senior Assistant Director, Investigations, IPOA, was being cross-examined by lawyers. This is with regard to the matter in question, where OCS Taalam from Central Police Station, IPOA wants him to be detained for the next 21 days as investigations continue. That is at the Milimani Court. Is a matter that is continuing. We continue to follow up. This is with regard to the death and murder of Albert Ojwang, a teacher and a blogger. As well, the same case, on another matter as well, but related to this one at the Kibra Law Courts. There is another matter where civilians have been arrested in connection with this matter and have been taken to court as well. The two cases going on concurrently, and we are there to bring you the very latest on what is happening on both matters. Again, at Kibra, civilians who are arrested with regard or in relation to the matter at hand, that is the death of Albert Ojwang, is ongoing at the Kibra Law Courts. And at the Milimani Law Courts, it is the matter where the IPOA is requesting to detain Taalam for the next 21 days.